updated email program. Neither Shannon or I could figure out how to print your email so that I would have a list of workers.
Okay.
Oh, interesting.
All right. Thanks, girl.
So if it's not clear, I may be asking you. Where I have reports, it's easy. I can just look at the reports.
Right.
But for pre-trials, I don't have reports, so I don't have the workers identified.
Right. That's
all right. Let me bring everyone in on the Lewis Eubanks Bradshaw. Who's the worker on that one?
That should be Emily Schell and Taryn Widener.
Okay, there's Michelle. There's Widener. Mr. Bradshaw. Mom. And it looks like placements. Oh, a couple different placements. Okay, looks like, well, I don't have quite a connection with Donald Eubanks yet. Let's wait for that before we go on the record. Having trouble establishing a connection with Donald Eubanks. Since he's not, oh, maybe we've got one now. All right, well, Shannon, go ahead and put us on the record, please.
His wife is here. Maybe she can tell him that we're just setting this for trial.
Okay, this is the matter of the Lewis Eubanks Bradshaw children. We've got Ms. Tucker representing the petitioner. Mr. Brown is LGAL. Ms. McCluskey represents the mother. Mr. Kelly represents the father. We have both parents present. We have Ms. Wiedner and Ms. Schell on behalf of the agency, and we've got foster parents present as well. In our off-the-record conversation, we discussed the possibility of resolving, at least as to some of the children, with custody orders. The agency is insisting that we move forward with a trial, which is their right. So we will do that. Although, again, as I've indicated in the past, except for egregious circumstances, I don't typically terminate the rights of only one parent when there is a parent who's deserving of having parental rights terminated, but the other is not. I usually resolve that with a custody order. But the agency is certainly entitled to a trial, so we will move forward with a trial. That will be July 20th at 1 p.m., assuming we have Dr. Gerton's report available by then. I can't imagine we would not. He's already looked at the documents. He's given some preliminary indication to parents' counsel as to his thoughts after reviewing the file. We just don't have a report, so I don't anticipate a problem. This looks like a solid trial date. Is there anything else the court needs to address on the record today?
No, Your Honor.
Very well. We'll see you all back here for the trial. Thank you.
I would let Ms. Eubanks know, Lena Eubanks, that I have notified the prosecutor that you do need another subpoena, and she will do so.
Thank you.
Next up is baby girl Sig.
The worker on that should be Samantha Kubik.
Okay, I see her. And it looks like we've got the mother, Stacy Sig, present. Okay, this is the matter of baby girl Sig. Mr. Brown is LGAL. Ms. Tucker represents the petitioner. Samantha, I'm sorry, last name?
Kubik.
For the, on behalf of the agency. And it looks like we've got the mother present. Ma'am, can you hear me?
Yeah.
All right, looks like we've got a poor connection. Is Mr. Bibbins present with you?
Is what?
Is that Mr. Bibbins
I don't
behind
really-
you?
Yes.
That's in the background.
Okay, so at least we're hearing you a little better now. I believe, if I'm not correct, this is the first time that either of you have been present for a hearing on your child. Is that correct?
Yes.
All right, I need to advise you that you have the right to an attorney, either one of your choosing or one appointed for you by the court. So first, Ms. Sig, would you like the court to appoint an attorney to represent you in this matter?
Yes.
All right, who's next up, Shannon?
Ken.
Mr. Ken Hotchkiss will be representing you. In just a moment, I will give him an opportunity to speak with you off the record. So Mr. And I'm sorry, I just lost the name. Mr. Bibbins, you are currently identified as the putative father. That means there's been no legal determination that you are the father of this child. Until your paternity is established, I would not typically appoint an attorney for you because you have very limited rights as a putative father. That can be fixed if you both believe that Mr. Brooks is the father if the two of you are willing to sign an affidavit of paternity, and we can make Mr.
We did
Bibbins-
that already.
Samantha, do you have that information?
I do not. This case has been transferred over to foster care, and I was told that the worker has scheduled a paternity test because another man has came forward saying that he is the father to baby girl Sig. And so there's a paternity test scheduled on July 12th for that person.
Who's the foster care worker?
Her name is Kyra Denton, and I believe she's watching over on YouTube.
She's in the waiting room. Let me bring her in.
Okay, she'll have more information on that.
Good morning, Ms. Denton. Sorry we're bringing you in late. I understand that you've been in communication with Ms. Sig and Mr. Bibbins concerning an affidavit of paternity and potentially a paternity test. Can you confirm?
Yes, I did set both. I did set Mr. Bibbins up for a paternity test.
All right. On the assumption that this paternity test is going to confirm his paternity, I'm going to go ahead and appoint an attorney to represent him so we don't lose any time. If he's excluded, obviously, he won't need representation beyond that. Well, let me confirm. Mr. Bibbins, do you want me to appoint an attorney for you?
You want an attorney?
Yeah.
All right, who's on the list, Shannon?
Rebecca is next, and if you could please make sure the parent's information is correct.
Yes.
What?
So give me just a second. I think we've got returns of service here, Shannon, so. Looks like Dad might have been served at work. So
No.
Ms. Sig, it's showing
Yes.
that you were served with the summons at 176 Laurie Circle. Is that where you're residing now?
What was that? No, 7005 Cement City Road.
Oh, okay. Did you get that, Shannon?
I need the 7055 Cement City Road, but what's the
I think she said 7005.
Yep.
7055?
7005.
And that's Cement City, and what is the zip, please?
It's Cement City Road. I'm assuming it's a Cement City address too.
Nope, it's Brooklyn.
Okay, Brooklyn, 49230.
Gotcha. I live
All right, and is Mr. Bibbins at that same address?
Yes.
Yes, sir.
Okay, very good. Can you give us a phone number as well?
517-435-6675.
Okay, so you have both received a copy of the petition in this matter?
Yes.
All right. Do either of you have any Native American Indian ancestry?
No.
No.
All right, so what I'm going to do, I mean, it's a little awkward because you're both at the same number. I'm going to set up a private meeting room
Mm-hmm.
so you can have a private conversation with your attorneys. I'm going to do that now. As soon as they tell me they are ready to proceed, we will do that, okay?
Judge, may I ask one question of Ms. Denton, just so we're on the same page? Miss Denton, is it my understanding that you are doing 2 paternity tests, one for Mr. Bibbins and one for someone else?
Yeah, someone else came forward reporting that he may be the father of the baby. So he's
Okay.
also scheduled for a paternity test.
Okay. And did Miss Sig and Mr. Bibbins fill out an affidavit of parentage or no?
Not to my knowledge.
Okay. They said they did.
Yeah, we did at the hospital.
The hospital told me they did not.
Yeah, that was my knowledge too.
Okay.
I can give you the papers.
Okay. Irrespective of DNA, if they file an affidavit of parentage, that's who the child's father is. So I'm wondering.
Well, if they filed one, if the
Correct.
hospital's saying they don't have one, then maybe it wasn't completed. And we know if they're not completed exactly correctly, they get rejected. So,
But the hospital is not the repository for an affidavit of parentage. That goes to Lansing. They may assist, but
I'm aware of that, Mr. Brown. We'll see what shakes out.
okay.
So I'm going to set up the private meeting rooms right now. Actually, just one because they're both at the same location. That was Mr. Kelly and Mr. Hotchkiss.
Just wait.
Yeah.
Shannon?
Hotchkiss and McCluskey.
Oh, okay. Okay, folks, just follow the instructions on your screen. When I see you come back into the courtroom, I'll know your conversation's over.
Shannon?
Hey, Ivan.
Hi, I'm wondering, are you going to give us another date on Almac and Lewis today?
I already did. I sent you an order.
Okay. I haven't looked at my email this morning. Was it this morning?
No, it was last week. I mean, I can give it to you right now, but I did it last week.
I would appreciate it. That would be nice.
I know. I am nice.
Yes, indeed you are.
All right, hang on one second, Ivan. Let me pull this up. Are you there, Ivan?
Yes, ma'am.
Okay, Almac is July 20th at 9:30.
Okay.
And what was the other one you were inquiring about?
Lewis, that was set for this afternoon.
Lewis is going to be August 3rd at 1 o'clock.
Thank you.
Mm-hmm.
All right, it looks like we can do the Dakota Johnson post-term while we're waiting. Let's go ahead and do that. You are LGAL for Dakota, Ivan?
Yes.
All right, let me look at the report and see. It's got Brenda 2 as the adoption worker. I'll let her in. And Joy Jennings, foster care, we'll let her in. So it looks like we've got everyone here for that. As soon as we get a connection, we'll move forward with that one. And looks like we have connections now. This is the post-term for Dakota Johnson. Mr. Brown is LGAL. Ms. Jennings is a foster care worker. And Ms. 2 is the adoption worker. So, Mr. Brown, how's Dakota doing?
Very well. Dakota's been with his maternal grandmother and all of his siblings since essentially shortly after birth. The adoption is going fairly smoothly and quickly because grandparent has went through previous adoptions. I see in the report that we're looking at June. I have no concerns whatsoever. And grandma indicated to me that all she wants is the paperwork signed so we can do it as quick as possible. Thank you.
And it looks like Calhoun County is going to be doing the adoption. Everything look like it's in place for that to happen this month? Ms. Chu?
Yes, Your Honor. I actually received word that I had, that consent arrived at my office last night. So after this hearing, I'm headed to pick it up and stick the petition in the mail. So I think we'll be done very shortly.
Very well. So what I will do, I will give you another post-term date, if necessary, August 31 at 8:45. But it looks like we should be finalized well before then. Thank you.
Thank you, Your Honor.
Thank you.
You're welcome. Have a good day. So we got Mr. Hotchkiss back.
I suspect that Ms. McCluskey is speaking with her client now.
Okay. I don't think we can do anything else until they're done. We were able to get one post-term out of the way. And we're a little early for any others. Actually, it looks like we could probably do Allard Hyland.
Judge, I need to talk to my client on that one. She hadn't got the report, and I emailed it to her this morning. Told her we had some few things going on, but you would put us in a breakout room when that was appropriate to go over that.
All right, let me bring everyone in on that one. I don't think I can create another breakout room until they're done with the one that I already made. If at the outset I create more than one, I can do that, but I only made one.
Okay.
Okay, this is a matter of the Allard Hyland minors. We have Ms. Tucker representing the petitioner. Mr. Hotchkiss is LGAL. Mr. Brown represents Mr. Hyland. And Mr. Kelly represents the mother. Mr. Kelly has asked for an opportunity to speak with his client in a breakout room but unfortunately I can't create a new breakout room. I wonder, Mike, could you just mute your microphone and give her a phone call?
Um,
Then we don't have to wait.
Could you unmute them so I could find the number I need to call?
Yeah, they can do that.
It's 810-238-7226, extension 323.
Okay. I'll give that a try.
All right. And I forgot to mention Ms. Aroka is here on behalf of the agency. So we will wait on them. But in the meantime, I see Ms. McCluskey is back. Let's see if her client figures out a way to get back in here. Sometimes that's a little challenging. I can close the breakout room and that'll force the issue. There we go. Okay, looks like we've got everyone back in here. Mr. Hotchkiss and Ms. McCluskey, how would you like to proceed this morning?
Your Honor, on behalf of my client, we would waive the reading of the petition. We would waive a right to probable cause hearing and ask that this matter be set for trial.
And Your Honor, I'm sorry, I missed this before I was appointed. I was present but not listening. So did the court receive a copy of an affidavit of parentage? Is my client now?
No, they thought they filled one out at the hospital. Maybe they did, but the hospital apparently didn't keep it. I'm not sure what happened to it. If one has been filed and accepted for filing, in Lansing, that pretty much puts an end to any need to establish paternity. But if these paternity tests conflict with that affidavit of parentage, there's a possibility somebody might file an action to set it aside. In the meantime, since I don't have confirmation of the filing of an affidavit of parentage, I think it makes sense to proceed with the paternity tests. And if there hasn't been one, we'll make sure one gets filed. So Ms. Sig, let me ask you, an affidavit of paternity, I know the hospital assists with something like that, but it's your obligation to file that with Lansing. Do you know if that happened?
I didn't know I was supposed to. I can make sure that gets done.
Do you still have the original affidavit?
Yeah. Yep.
All right. Well, why don't you show that to the worker until it's filed and accepted for filing. It's not something we can act
Not valid.
on.
Okay.
Well, it may be valid. It just hasn't been accepted yet. And I know they're sticklers. If you crossed out something on the form, you changed a middle initial, or you changed the spelling on something, and they will not accept it. There can't be any corrections on it, or they will not accept it. So, Ms. McCluskey, how did you wish to proceed today?
Your Honor, so I guess we would just request that the DNA test be completed, and obviously with my client being only putative, I don't know that we have standing to request anything else at this time.
Well, I am going to go ahead and set the matter for trial. Well, the date that Shannon had identified, I don't know that it's realistic. It's just next week, and we need to get the paternity tests done, and if there's an affidavit, get it filed. So we probably should be looking sometime in July for a trial date, Shannon?
It was set that early because we had nothing with the parents yet.
Yeah, we hadn't had contact with them. I understand that.
I'm gonna leave this up to you when you want it set, because we've got all kinds of things coming up in July. We've got Lewis Eubanks, we've got Nefer. So when would you like me to set this?
Well, I don't know when all those other things are set. What's our
In
first,
the afternoon,
which date? Which,
July 13th.
so July 13th looks like a full day.
Well, hang on. The afternoon looks like a full day.
And how does July 20th look?
That's Lewis Eubanks and Bradshaw.
So that's pretty full.
That's the afternoon, unless we want to do this in the morning.
I guess it depends on how late the morning is. How do either of those mornings look?
The 20th, we have the Almac bench trial in the morning.
That should be quick, I would think.
You think it's realistic that if the DNA is July 12th, that we're getting it in within 1 week?
I don't, when is the testing scheduled?
July.
I didn't hear that.
July 12th.
Oh, I'm sorry, I missed that. Yeah, I think Ivan's right, Shannon. We need to look at a later date. So the next one would be the 27th.
Yep, and that's Nefer's in the afternoon.
How does the morning look?
I mean, typical morning. We could do it at 10:30.
Let's do that. July 27th at 10:30. Obviously, if we run into a snag with the paternity results, and it's necessary to adjourn, we can always adjust the trial date. What are the recommendations for parenting time pending our trial date?
Suspended at this time.
Counsel, do either of you wish to speak to parenting time?
I do, Your Honor. My client has not had an opportunity to visit with the baby since she was in the hospital, and would like an opportunity to have at least supervised parenting time pending the trial. Thank you.
This is a newborn that, if I remember correctly, was essentially abandoned at the hospital. Am I remembering that correctly?
Yes.
Was the child born? Did the child test positive for substances?
Yes, she tested positive for 8 substances.
And this is a request for permanent jurisdiction, correct?
Yes.
I think I'm going to keep parenting time suspended.
Thank you, Your Honor.
Okay, hopefully everything goes smoothly with the paternity tests, and we'll look to see you all here on the date that I gave you earlier.
Judge, will you address the issue with the foster parents going out of state and the agency being able to authorize medical?
Yes, I've included that in my order. Hold on a minute. Getting my files shuffled here.
Don't have to.
If the parents are available and willing to consent to necessary medical care, I'd like the mother to do that. But if she's either unwilling or unable or unavailable, I want the agency to be able to consent. So, but I at least want you to, now that we have contact with mom, give her that opportunity. Her parental rights have not been terminated yet. So that is a proper role of a parent. And I will authorize the foster parents to travel out of state for vacation travel. Okay, we'll see y'all back here on the trial date you were given. Thank you.
Thank you.
Thank you.
Thank you.
Mr. Kelly, are you ready to proceed?
And Patrick,
All right, I'm assuming that was a yes, but you broke up just as you said it.
yes, on Patrick, yeah, yes, Your Honor, we are prepared to move.
Okay. So, you've got down everyone who's present, Shannon?
Yes, I do. Thank you.
Okay. All right, we are currently scheduled for trial on this on June 22nd at 1:15. We schedule, well, is this just a routine 90-day review hearing?
I believe it is, Your Honor, but we'd have a request in relation to the trial date. We're having a witness
All right,
issue.
well, all right, well, let me first ask Mr. Hotchkiss, how are the children doing?
Your Honor, I had contact with the children before our hearing on May 18th. At that time, they were doing well. That was prior to the court suspending the visits. It's my understanding that the children are doing better since the visits have been suspended. And I think that's articulated in the report. They're in the same placement that they've been in off and on for the last 2.5+ years. It's a great placement for them. They've adjusted very well. And I think they, as well as the grandparents, are looking forward to permanency. As I understand, we have a termination hearing next week. And I'm in favor of the goal change as well as the recommendations in the report. Thank you.
So, Mr. Kelly, what was the witness issue?
Your Honor, my client has gotten to the point where her stay at Odyssey House, she is in the process of getting a clinical psychological evaluation, which would provide a picture to the court in terms of not only her progress there, but her prognosis moving forward, her ability in relation to the things that she's learned in application, as well as what it's likely going to be real world. It consists of a number of different interviews, which she has started. The evaluator is a Dr. Dunn. He is only available limited times. These are only offered sporadically throughout the stay at Odyssey House. She's gotten hers going, expects to have it completed within 30 days to have that done. I think that's an important part of her presentation to this court, because essentially for her, it's the issues are drug use, abuse. And I think this court would demand a large level of assurance from her in determining if it would not terminate parental rights, to give her another opportunity to continue to move forward and continue with her work at Odyssey House. And I think that evaluation would be a big piece that I think the court should consider. I'd understand if we were just at adjudication, it may not be 100% relevant, but we are at the phase where you're looking to permanently and forever terminate her parental rights. And I think all the information that the court could have before it to make an informed decision is not only appropriate for the court, but I think considering the rights that she has at stake are important for that to occur. So I would request to the court that the matter be adjourned. I believe we have an August 2nd date for the Lewis matter that was adjourned yesterday. That should be more than adequate time for her to get that evaluation done, get a copy of the report to Ms. Tucker in case she needs to, in case she wants to have, I can't recall who did mom's psych eval in this case, to review that or otherwise prepare for Dr. Dunn to be able to testify.
Is anyone opposed to an adjournment?
Ultimately, I would leave it in the court's discretion. I would just state for the record that obviously we would like to move forward in a manner that gives the children permanency sooner rather than later. But I certainly can respect the request of Mr. Kelly. And so again, I would just leave it in the court's discretion.
So I don't want to deny the mother the opportunity to present whatever evidence that she might have, although the challenge here is the amount of time that these children have been out of care. If we were talking about mom being in a healthy frame of mind within 6 to 9 months after the children were removed, I'm going to be a lot more receptive to that kind of information than I am mom being in a healthy state of mind for 2 of the children over 3 years after they were removed, which is, and particularly in light of how the children are doing. But nevertheless, I don't want to foreclose her from an opportunity to present whatever proofs that she reasonably is able to do so that she gets a fair trial. So I will grant the request for an adjournment. That was it August 3rd?
I have August 3rd at 1 o'clock for that Lewis trial. That was the date Shannon gave us.
So you want this one on the same day? Is that what you're saying?
Well, I'm not sure what you're saying. I thought you were telling me that day had just opened up, Mr. Kelly.
Oh, that was the next day I saw. I know you just put Bradshaw on the 20th of July. That's going to take a good part of the afternoon. I'd imagine this would too. So, and just to give the amount of time to make sure we have that report, whatever date the court can fit it in.
August 10th at 1:15.
August 10th, 1:15.
That'll work. We'll make it happen.
And all prior orders will continue.
Your Honor,
Thank
I
you.
would just
Yes.
like to add that I got notification yesterday that Dustin Hyland Sr. was actually moved to the Ionia facility. So I wanted to make sure to provide that address and contact information to the attorney.
Okay, and if you could pass that on to Shannon as well, because we'll need to, or to
Prosecutor's
the
office.
prosecutor's office rather,
Sure.
because they'll need to arrange for his presence.
Sure, I will send out an email as soon as the hearing is done.
Okay, thank you.
Thank you, Judge.
Okay, let's see. I think Malou is next. Malia, Chevelle, and Callie. And let's see, we've got Brittany Haynes. I don't see either parent present.
Yes, I spoke with my client yesterday. She's having some problems with her computer. She's requesting that you call her, and I have the number right here.
All right, go right ahead.
615-9402.
517 number?
I believe so, yes.
I hope so. I'm sorry, what's her name?
Stephanie Hadley. It is 517.
Hello.
Hello, is this Stephanie Hadley?
Yes, this is her.
Good morning. This is Judge LaFlamme.
Good morning.
We are on the record in the matter of your children, Malia, Chevelle, and Callie, or Kaylee, which is
Yeah. It's Callie.
Callie. Okay, so Ms. Tucker's here representing the petitioner, Ms. McCluskey's LGAL. Mr. Brown represents Ms. Hadley. Is Dad have counsel?
Yes, Your Honor, I represent Mr. Blue.
Okay. He does not appear to be present this morning.
And I have two telephone numbers for Mr. Blue. However, neither one of them are working, so I was unable to reach him prior to the hearing. I don't know if the caseworker has any additional information as to how to reach him or not.
I have been communicating with him through Miss Hadley's phone number as well, because he hasn't provided an additional phone number at this time.
Ms. Hadley, is Mr. Blue present with you currently? Ms. Hadley?
I said that he was right here next to me. I apologize.
Oh, okay. No, we didn't hear you say that. It didn't come through. So thank you.
I actually had my phone on mute. I'm sorry.
All right. Fair enough. All right. So Mr. Hadley is present by telephone. Or I'm sorry, Mr. Blue. Okay. So, and we have Ms. Brittany Haynes on behalf of the agency. So Ms. McCluskey, how are these three children doing?
Overall, they seem to be doing pretty well. Malia struggles the most according to placement. She kind of has a quick temper when things don't go her way, but otherwise everyone's doing well. They're bonding appropriately to placement and adjusting. So this is a great placement. I have no concerns. I reviewed the report. Obviously, there's not a lot of progress being made, but I'm in agreement with the recommendations. Thank you.
And Ms. Haynes, what's your view of the parents' progress?
Parents have been making some progress on some of their services. I do have a few updates from the court report as well. Ms. Hadley was able to get a counseling appointment scheduled on 6/22. And then there was one error on the court report, so I apologize. Mr. Blue did have a positive screening for methamphetamine on 5/17. I had clicked on the incorrect one 2 times instead, so that was an error on my end.
Have his other screens been negative?
They have been positive for marijuana, for THC.
But negative for anything else?
Correct.
All right, well, I'm glad to see there's some progress being made. I think it's important for both of you to be diligent so that we can move this case forward. I think the recommendations, well, let me ask, Mr. Brown, Mr. Hotchkiss, do you wish to speak to the recommendations?
Agreement with the recommendations. I had a conversation with my client yesterday, stressing the importance of making every drug screen, and my client indicated that she will. So I think that's the only thing that is really not looking good at this time is haphazard drug screens. And I've stressed to her the importance for the court of regular, prompt drug screens. Thank you.
On behalf of my client, as indicated previously, I haven't had an opportunity to discuss the report or the recommendations with him. In reviewing the recommendations, they seem to be appropriate. I would encourage him to contact me after this hearing at some point so that we can have a conversation about the services and the importance of participating. Thank you.
All right, so we will implement all of the recommendations. We will set our next review hearing for September 14th at 8:45, and I hope that I see continued positive engagement from both parents so that we can advance towards reunification. So we'll see you all back here September 14th at 8:45. Thank you.
Thank you.
Have a good day, folks.
Yes, you do.
Okay. Excuse me. Next up is Darnell Miller. So let's see. We've got Ms. Tucker for the petitioner, Ms. McCluskey's LGAL, Mr. Kelly represents the mother.
Your
And
Honor.
let's see. Yes.
Your Honor, I have this in my book for June 20. I have this in my book for actually June 29th. But I did notice Miss Carroll had it on for this morning. My client's usually present. I don't, unless she's in a waiting room, I don't see her up on the screen.
Her name is Heather Miller, correct?
Yes, Your Honor.
She's definitely not on the screen. I can try to reach her by phone. Just a moment here. Shannon, the last order does say June 29th at 9:15.
Then it could,
Let me,
then I guess I screwed up. We
let me,
can,
let me see if I can get her by phone. Otherwise, we'll just adjourn it to the 29th. Let me check.
Your Honor, I think that's the date that the court gave the attorneys off, but that's why the date was moved.
oh yeah, that's exactly why. Thank you,
Oh,
Carl. You're
we're
right.
not going to be here on the
You're welcome,
29th.
Carol.
I
Thanks
do.
for
Happy
that.
birthday to me, by the way. That is my birthday.
Whose birthday?
Wheezy,
That
she's
is my
turning
birthday, the
60.
29th. Just throwing that out there so everyone remembers.
Well, that's why we scheduled the day off, is because it's your birthday.
Exactly.
There's going to be a parade and everything.
Then there should be a new notice in there then.
Hopefully.
I'm sure there is. I just looked at the order. All right, let me see if I can get Mom by phone. If we move the other direction, we run afoul of the 90-day review.
Hello?
Hi, is this Heather Miller?
Yes, it is.
Ms. Miller, this is Judge LaFlamme. I see you're logged in now.
Yeah, it kicked me out and then I logged back in.
All right, hold on. Let me try that.
And we need the worker in as well, Your Honor.
And that is Bailey Roberts. Okay, we'll let her
Yes.
in.
Well,
All right.
I'll get you some. let me finish talking with the judge and then I'll get you some medicine, okay?
All right, we're going to keep the phone link open, Ms. Miller, until we see the other connections made.
Okay.
Oh, it looks like it is. At least I've got an audio connection. I'm surprised we're not getting a lot of feedback. That's what normally happens when I have two audio channels open. All right. Well, let's just move forward with this. Okay. Worker is now present. And let's see, Ms. McCluskey. How is Darnell doing?
I reached out to his caseworker and his therapist, but I was not able to make contact with them. So I was not able to get a more detailed update. I did review the court report. It looks like Darnell's doing very well for the court report. I just was looking for a more detailed update from one of those individuals, but was unable to get it. So I did review the report. I'm in agreement with the recommendations. Thank you.
And Ms. Roberts, if you could express to placement the importance of communicating with the LGAL so that she can do her job. Do you have anything to add to your report?
Yes, Your Honor, I do. We received the trauma assessment results, and there was nothing concerning, but we did receive that, and I should have put that in the court report.
So your recommendations remain as stated in the report?
Yes, Your Honor.
And Mr. Kelly, do you wish to speak to the recommendations?
I've reviewed the CTAC report. I don't agree that it doesn't say anything concerning. Miss Miller was advised by at least two of the doctors. It's not a matter of if Darnell is going to do something again. It's just a matter of when. But fortunately, he's getting the assistance he needs where he's currently at. Miss Miller had her parenting time and all communication from him suspended for at least 3 weeks. There was no order for that. Apparently, there might have been a investigation going on. I believe that's still ongoing. But again, there was no court order for that. The agent DBI would not allow her to even visit or speak with this child. And if the court reviewed the CTAC assessment, they advised that it was very important for that relationship to continue and maintain, considering his level of functioning. I can only imagine the amount of confusion that set in for that kid when his mom was unable to even communicate with him. Miss Miller's had difficulty having direct communication with this worker. She has attempted contact and it goes through a supervisor and then it comes back around. And instead of just directly responding, we have this whole circus going on. She advises me that when she finally did get through to placement at DBI, they said, well, we forgot that we had phone calls for the past 3 weeks. There's a lot of shenanigans going on that are at the expense of this kid. My client is supportive of him. She is willing to follow the recommendations of that CTAC assessment because it is important for him to maintain that relationship. She wants to maintain that relationship and will continue to do so. There's some discrepancies in the report in relation to the relative search engagement where it indicates Ms. Miller was unwilling to provide contact information. That's not true. She wasn't actually even asked to do so. But she did tell them many of her relatives were afraid because Darnell had been physically aggressive with them. But in the beginning, when this all occurred, she did call sisters and brothers, but is still willing to provide a list, but she wasn't asked. So I think it's a little bit inaccurate to suggest she's essentially not cooperating. Again, she's supportive of Darnell. We would hope that her communication is reestablished and continues because I think that's very important in accordance with that CTAC assessment, considering his level of functioning and where he's at. And we wanted to break the news to him about him unable to come home a long time ago. And for whatever reason, that wasn't agreed to, but as you can see through the CTAC assessment, that information needed to be had. Again, Your Honor, the recommendations as written, we don't have any objections to, but we did want to provide that clarification for the court. Thank you.
So, Ms. Roberts, is placement aware of the CTEC assessment?
Yes, Your Honor, they are.
We've run into problems in the past where placement has a difference of opinion with the recommendations from a CTAC assessment. And unfortunately, the two don't seem to speak to each other prior to an assessment being done. But certainly afterwards, it would make sense that there be some communication to make sure everybody's on the same page here with this child. Do you know if that has occurred?
Yes, they were a part of the FTM. Was it an FTM or the meeting that CTAC holds with the worker and with Heather Miller to review the results? And we invited the clinical director from placement to participate as well, so that she could provide insight, feedback, and be aware of everything that the CTAC provided. So
It would be good if we could have placements participation the next time we have a review hearing. If you could communicate them to them, I think whenever I have a child in a residential facility, I like to have the child present at the hearing along with somebody from placement who can speak directly to how he happens to be doing on any given day. Can you please communicate that and make sure we have Darnell present for the next hearing?
absolutely, yes, Your Honor.
Who's your contact at placement?
I have a few, which I've provided to Ms. McCluskey, I know, but I have the clinical director, his caseworker, and his therapist.
And what are their names? Do you have those handy?
Yeah, the clinical director is Erica Coates. His caseworker is Micaiah Harris, and his therapist is Karen Freeman.
All right, I just wanted to make sure none of those people were sitting in my waiting room. I didn't think so, but all right. Well, thank you. I believe the recommendations are appropriate. Mr. Kelly's objections and clarifications to some of the matters stated are noted for the record. We will set our next review hearing for September 14th at 8:45, and I am going to include in my order that placement, a representative from placement and Darnell should be present via Zoom for the next hearing, assuming he's still in that placement at the next hearing.
Thank you, Judge.
Thank you. Next, we have a post term for Darice Lafitte. And let's see, I've got Courtney Ross in the waiting room. And let's see. Ms. McCluskey is LGAL. So Ms. McCluskey, how is Darice doing?
I reached out to placement. I was not able to make contact. In their defense, I did not give them a lot of time. I just reached out recently. But this placement's wonderful. They go above and beyond to meet Darice's needs. So I have no concerns at all. I reviewed the court report and I am in agreement with the goal of adoption. Thank you.
So Ms. Ross, is there an adoption worker assigned?
I am the adoption worker and the foster care worker.
Oh, okay. Two hats today.
Yeah.
Anything to add to your report?
The order placing Darice and his adoptive placement was signed by Eaton County on June 7th of 2021. We should have the final order of adoption either this week or next.
Wonderful. That's good news. I will set a review hearing just in case for September 7th at 8:45, but I truly believe that will not be necessary. Thank you.
Thank you.
Have a good day.
You too. Have a good day, everyone.
And let's see, now we've got a prelim for Genesis Davis. Are we early on this? Looks like we are. Just a few minutes. While we're waiting for the clock to strike 10, I'm going to take a moment to review the petition.
I don't know any of these people.
Ms. Walesby, you're here on the matter of Genesis Davis?
You know who that is? No. Okay. Nope, she's not here for Genesis Davis. She doesn't.
So I'm sorry, I don't have anything else on my calendar this morning. What matter are you here for?
Oh, here. I'm going to turn the camera a little bit. Hi, Katie was told by her DHHS worker to join your Zoom for a 10 a.m. hearing.
Oh. Well, it's not quite 10 a.m. We'll keep you here and maybe somebody else will show up and explain to me why Katie's here.
Okay.
I don't see her name.
Okay, well, maybe her caseworker got the date incorrect, right? Cool. Okay. Thank you.
All right, I do have another worker here. Let me bring her in. Ms. Potter, what matter are you here on?
Morning. I'm here as a support to the Octavia Davis case. I was the ongoing worker, but I am not the petitioner.
Okay, fair enough.
Thank you.
That would be a different case, I believe. So, well, we'll go ahead and exit the Zoom, Your Honor, and I guess we'll get with her DHS worker.
It's not quite 10 o'clock yet. Why don't you sit tight and let's make sure if someone else shows up, we might be able to shed some light on this for you.
Okay, I'll just mute and turn our video off.
Okay. Okay, I've got one other person. Let me let him in. And it is now just after 10 o'clock, so I think I can call this case. This is the matter of Genesis Davis. Ms. Tucker is here representing the petitioner. Mr. Kelly is LGAL. Let's see. The mother's name is Octavia Davis. And at the time of the initial prelim, it looks like she was in jail. Is she still in jail? Do we know?
Yes, she is, Your Honor.
I was just told a half hour ago to request her, and I said I couldn't do that with a half hour notice.
I'll just call over there. They're pretty good about responding. So she has requested an attorney. Did you appoint someone?
No, I left it. But it's in the.
Hi, this is Judge LaFlamme. Sorry for no advance notice, but would it be possible to bring Octavia Davis into my meeting room?
I think we can arrange that for you.
Wonderful. Thank you.
All right. And you said you want her in person, right? Just to clarify.
No, she can be to the polycount.
Oh, okay. All right. Not a problem. We'll get her going.
Thank you.
You're welcome.
So it appears she did request an attorney at the initial prelim. So we're going to appoint
Ivan is next.
Mr. Ivan Brown as her attorney. As soon as she shows up in the waiting room, Mr. Brown, I'll connect you with her so that you can have a private conversation with her.
Hey, Miss Tucker, I don't know if you have anything for a no contest. I reviewed this petition. Do you have any documents whatsoever that you can forward to the judge? So while I'm talking to her, he can review some sort of document?
I don't have anything yet. I don't believe. Mr. Oliver, do you have a 154 investigation that has been approved by your supervisor yet?
No, not yet.
Not yet.
I could just take some testimony from Mr. Oliver if he can establish a factual basis.
That's fine with me, Your Honor. While we're waiting, if the court would indulge me, I would like for your order to ask for, or to allow us to publish putative father notice. We don't have a good address for the putative father. I don't know if Mr. Oliver has had any contact with him, but without an address, I can't send him notice. So I'd like to be able to publish that.
So we have been able to make, I haven't been able to make contact with him, but I was told by his father that he currently resides at 1901 Plymouth, Jackson, Michigan. We've made several attempts to get in contact with him, but have been unsuccessful. But we were told that he does reside there.
So that was 1901 Plymouth Street in Jackson?
Yes.
Okay. Well, I will start by trying to send putative father notice there.
All right, and we will I will authorize, if you're unable to locate him, that you be able to publish.
Thank you.
So I've got someone present here who was told to appear, but it doesn't sound like she's here on the right case. Her name is Katie Walesby. Can somebody shed some light on this for me?
Your Honor, this is Melissa Taylor with CPS. I'm sorry, I was told by Referee Stone yesterday that we did have a hearing for this abuse and neglect case this morning at 10 a.m. So that must have been a miscommunication or misdirection on.
Or they didn't bother telling us. Maybe we can track down the file. If she did a prelim yesterday, certainly.
Your Honor, I got a copy of the petition too.
All right, we'll try to track this down. It's probably in on my counter. There's a big stack of things there because I was on the bench
Okay.
all day yesterday. Thanks to Ms. McCluskey. Well, it wasn't just her.
I heard that.
Miss Taylor, can you send me a copy of that petition? I'm not able to locate it for whatever reason.
Yep, will do.
Thank you.
All right, Shannon's got the file. We will
I mean, nothing's prepared on it, so.
That's all right. That's all right. We can, we're still waiting on the jail to produce mom and Genesis Davis. Let me take a look at this file and see who all is on this one.
I'm guardian.
So,
Judge.
yes. Pardon? All right, this is the matter of Katie Walesby. And let me take a quick look at the petition. Mr. Kelly is LGAL on this one. Okay, and Katie is present, I believe, at Children's Village.
Correct.
And what is your name?
Katie Walesby.
Oh, you are Katie. Okay. I saw
Yeah.
someone earlier wearing a mask. Was that you?
Yep,
Yes,
you did have a mask.
Yes, I did not. I did have a mask on.
Okay, that's why I was puzzled. Sorry.
It's all right.
All right, give me just a moment to look at this petition. So this is a dependency petition. Do we have either parent present on this? I can't tell. I don't think so.
No, they were informed of the hearing, Your Honor, so I'm not quite sure, but they did have the information.
Okay. And I see Katie's been charged with domestic violence. Has there been an attorney appointed in the DL matter?
Yes, there has, Your Honor.
Who is that?
His name is Andrew Kirkpatrick.
Okay. All right. So Mr. Kelly has been appointed to represent your best interests, which may or may not align with what you desire to have happen. Sometimes in a neglect matter, when the LGAL disagrees with his charge as to what's in the charge's best interest, I can appoint a special advocate. Mr. Kelly, have you had an opportunity to speak with Katie privately?
No, Your Honor, I just got a copy of this petition myself.
Would you like an opportunity to do that now?
Yes, thank you.
All right, Katie, I'm going to create a breakout room.
Okay.
I'm gonna, once you get in there.
I'm going to put you and Mr. Kelly in there so the two of you both have an opportunity to speak. Wait a minute, I gotta, you were logged in twice. So I'm gonna remove this other login because I can't tell which is which when I'm creating a. Okay, just follow the instructions on your screen. When I see you're back in the courtroom, I'll know you finished your conversation. Uh-oh, did we lose her? Looks like we did. Okay, so I've been going back and forth with two different cases here. So we're still waiting on the login from the jail. So it looks like we can't do anything until we get everyone present. So we'll sit tight for now.
While we wait, Your Honor, I was able to get a document that could serve as a factual basis for the Davis case if Mr. Brown chooses to enter a no contest plea today. I sent it to Shannon and to Mr. Brown.
Okay. Thank you. I'm going to call booking again. They usually get people present within a matter of a few minutes. I wonder if they've run into some kind of a snag. Oh, here we go. Good morning. You are Octavia Davis?
Yes.
All right, Ms. Davis, Mr. Ivan Brown has been appointed to represent you as an attorney in this matter involving your child Genesis. What I'm going to do is I'm going to put you and Mr. Brown into a breakout room so that you can have a private conversation.
Okay, thank you.
So there should be instructions on your screen to join that breakout room. Strange. Looks like they're there. Just shows up differently on my screen than the other one. Okay, Mr. Brown, are you ready to proceed on the Genesis Davis matter?
Yes, sir.
And that will be a no contest plea?
That is correct.
The reason for a no contest plea is potential criminal and civil liability?
That would be correct.
Okay. Ms. Davis, would you raise your right hand, please? You do swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
State your full name, please.
Octavia Lynn Davis, my bad.
You are the mother of Genesis Davis, born on August 15 of 2019.
Yes, sir.
And was Genesis found in the county of Jackson at the time the petition was filed?
Yes.
Have you read the petition that was filed in this case, and do you understand the allegations that are made in it?
Yes, I do.
If the court accepts your no contest plea today, there will not be a trial, and you would be giving up all of the rights that you would have at a trial. Those rights include the right to a trial by a judge or by a jury, the right to have the petitioner prove the statements in the petition by a preponderance of evidence, the right to question the witnesses who testify against you, the right to give testimony on your own behalf, and the right to have witnesses subpoenaed who you believe would testify in your favor. Do you understand that you will be giving up all these rights if I accept your plea today?
Yes, sir.
If the court accepts your plea, the following consequences might happen. There will be continued investigation by the caseworker to see what the problems are in your home and family and how and whether they may be solved. The case could be dismissed if there's no need for further court involvement. If there are problems in your home and family that can be solved, the court could make your child a temporary ward of the court, place her with either parent, with relatives, or in foster care, and order programs and services designed to solve the problems. If the court determines you are unable to provide your child with a suitable home in a reasonable period of time, the court could terminate your parental rights, and your plea can be used as evidence in a proceeding to terminate your parental rights. Do you understand each of these consequences?
Yes.
If your parental rights are later terminated, your obligation to support your child will continue until a court modifies or terminates that obligation, until an order of adoption is entered, or until your child is emancipated by operation of law. Excuse me. Appellate review is available to challenge an order of disposition following adjudication, and that challenge can include any issues leading to the disposition, including errors in the adjudication process. If you wish to seek appellate review and cannot afford an attorney, one will be appointed to represent you on appeal and to assist you in obtaining court transcripts. You may be barred from challenging the court's assumption of jurisdiction on appeal if you do not file a timely appeal of the initial dispositional order. Do you have any questions today about anything I've told you so far?
No, I don't.
Has anyone threatened you or promised you anything to get you to enter a plea today?
No.
Are you entering this no contest plea of your own free will?
Yes.
Do you understand that I will treat a no contest plea the same as I would an admission of responsibility?
Yes.
I have been provided with an excerpt from the CPS report, which has been marked as Respondent's Exhibit 1. I have already taken the time to review that while Mr. Brown was consulting with his client. Counsel, do you believe that the court has complied with MCR 3.971?
Judge, you didn't ask whether there was any Native American Indian history.
No, I don't normally, but I can ask that now. Do you have any Native American ancestry, or does the father of your child have any Native American ancestry?
No, Your Honor.
Yes, you have complied.
I do accept the plea. I find that it was knowingly, understandingly, and voluntarily made. And I find that Respondent's Exhibit 1 supports that one or more of the statutory grounds alleged in the petition are true. Are we prepared today to proceed with disposition?
Yes, Your Honor. I believe Shauna Watson is going to be handling this case as the foster care worker, but she did send me the recommendation that I can read into the record.
If you would, please.
Yep. The agency recommends that Ms. Davis participate in a substance abuse assessment and follow the recommendations, participate in random drug screening, complete a psychological evaluation and follow the recommendations, participate in parenting classes, and obtain housing and legal income.
Mr. Brown, do you believe those recommendations to be appropriate?
Basically, yes. For the court's information, my client is about ready to go into recovery court. I would like those services to be coordinated. I'm sure as a part of recovery court, a substance abuse evaluation is going to be had. Random screens are going to be had. I don't remember, there was one more after parenting classes that I didn't catch.
I have no problem including in my order that services shall be coordinated with recovery court to make sure that there's no duplication.
And the other, Judge, psychological evaluation is warranted. However, I can't agree just to carte blanche, say yes to anything that's recommended. I would ask that she take a psychological evaluation. We should be back here probably about the time that psychological can get completed, and we can discuss whether they're appropriate or not.
All right, well, what I'm going to do is order the psych eval, follow recommendations, but with the ability to object to any recommendations that you find to be inappropriate.
Thank you, Your Honor.
Let me set a review hearing date before I forget.
September 14th at 9.
September 14th at 9 a.m. We also need to deal with the putative father, I understand he's been identified as Jovan Snyder.
Yes.
Ma'am, can you confirm that this is who you believe to be the father of your child?
Yes, I believe that's the father of my child. I'm almost certain about it. He just doesn't want to do a DNA test for some reason.
I don't compel DNA tests in a neglect proceeding. All I will simply do is give him notice of a putative father hearing, giving him the opportunity to appear and establish his and to establish his paternity of the child. If he fails to do so, then whatever paternal rights he may have will be lost. So we need to do notice. Do we know his address so that we can serve him, or am I going to have to publish?
We got his address already, Your Honor, but you did also indicate that you would include in your order that we could publish if we can't locate him.
Okay. It looks like I started writing that down on the order when somebody new must have appeared. Give me just a moment. The putative father hearing, if you want to, in the notice, Kelly, just identify a date on my normal Tuesday morning docket. You could pick one, just let Shannon know what it is.
No, I'll pick it because.
Never mind, Shannon will let you know what that is.
Okay, that's probably better.
At least a couple of weeks. Because if they gotta publish, let's make it 4 weeks.
July 13th at 9:15.
July 13th at 9:15.
Thank you.
Okay, Ms. Davis, I'd like to tell parents who are respondents in neglect proceedings, this is not a criminal proceeding. The purpose of this proceeding is not to punish you. The purpose is to protect your child and to provide you with whatever tools we possibly can to make it possible for your child to be reunified with you. That is our goal. That is our desire for you. We want you to do well. The best place for your child is with you. And we just need to make sure that conditions are safe for the child to be with you. So I wish you well. I hope you fully engage in services and that someday soon I'm able to reunite you with your child. Good luck.
Thank you so much.
We didn't address parenting time. I'm sorry.
What's the recommendation for parenting time? Thank you, Ivan.
So it is DHS's recommendation that upon Mrs. Davis's release, she gets visiting supervised by DHHS or designee. Hello?
Supervised by the agency or designee as a recommendation, Mr. Brown.
That's great. Thank you.
Great. We'll see you back here for the putative father hearing. Thank you, everyone. All right. Now we can turn back to the matter of Katie Walesby. Mr. Kelly, you've had a chance to visit with Ms. Walesby. Will it be necessary for the court to appoint a special advocate for her?
I don't believe so at this time, Your Honor. She just had some questions about these proceedings in relation to her juvenile proceedings. I think we were adequately able to explain those things to her. So I think at this point in time, there's no need for an advocate.
All right, and I think, Ms. Tucker, I need to take some testimony to establish probable cause.
Sure. My witness would be Melissa Taylor.
Ms. Taylor, if you could unmute, raise your right hand, please. You do swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank
you. Put
you.
your hand down, state your full name for the record, please.
Melissa Taylor, a CPS worker for Jackson County DHHS.
Go ahead, Ms. Tucker.
Thank you. Ms. Taylor, you are employed by the Department of Health and Human Services?
Correct, yes.
And it's through that capacity that you became involved with a minor child, Katie Walesby, date of birth August 6th of 2003?
Yes.
Your understanding the legal father of that child is Philip Walesby, date of birth May 17th, 1971?
Yes.
And the mother of that child is Beverly Walesby, date of birth July 28th, 1972?
Yes.
Can you tell me how Katie Walesby came to the attention of the department?
Sure. Katie's case originally started as a prevention case. Following her criminal proceedings, her legal adoptive parents were ordered by Judge Bates to have no contact with her due to domestic assault. So we as an agency took on a prevention case and put Katie in respite care with a local family or a local individual here in Jackson. Just this past Saturday, June 12th into the 13th, Katie was feeling suicidal, which resulted her in going to Allegiance Hospital to be evaluated. Our respite care that was originally taking care of her stated she was unable to care for her, which resulted in the removal of Katie, which was an emergency in the middle of the night removal this weekend, and placement was at Village, which she's currently at now.
Is it fair to say that because of the no contact order and because respite care refusing to take Katie back into their home, that she is without proper care and custody?
Correct, yes, that's the removal, yes.
Okay. Is there anything else the court needs to know about Katie's circumstances?
Not at the time. We are looking for other placement as Children's Village is used as a temporary placement. Katie has significant mental health needs that require around the clock care. And so we are trying to find better placement that will meet her mental health needs. That will be better for her. So we're just working on different placement right now.
Thank you. Your Honor, I believe that establishes probable cause that the child is without proper care and custody. Thank you.
Well, for a dependency petition, I need to establish that, well, one category is the child is homeless or not domiciled with a parent or a legally responsible person. I do believe that Ms. Taylor's testimony establishes that basis. This isn't a situation where she's repeatedly run away from home, is it?
No, Your Honor. There's a significant past of just with the mental health and constant hospitalizations in and out, and that's where the adoptive parents have just struggled with Katie.
No, I understand. All right, I do find that's a proper basis for the case for the court to find probable cause. We need to schedule this matter for, I'm not sure, we don't really need a pretrial. I do need to establish a trial date so that I can formally take jurisdiction I don't have a parent who can enter a plea, so basically I'm going to have to establish that through similar testimony at a trial. Shannon, can you give us a trial date? You can set it for a morning date, and it can be pretty promptly. I think we can get this moving along quickly.
We can do it in the afternoon. It'll be August 17th at
I was hoping to get it done sooner so we can get Katie moving along.
Okay.
Your Honor, we have that date that just opened up next week for Bradshaw. It's at 1 o'clock.
Let's do that.
Yeah, we can do it. And June 22nd at 1 o'clock.
June 22nd at 1 o'clock. So we'll see you back here then. Katie, did you have any questions for me?
No, Your Honor.
Your
All
Honor?
right. Yes.
Will either one of her parents need to show up to that meeting?
They are invited to come. I like to see parents participate. They're not required to come.
Okay, thank you.
I can let him know, Judge. I'll let him know of the hearing and at least give him the information.
Wonderful. All right, I think that concludes our docket today. Thank you, everyone. Have a good day.
Thank you.